What starts as a routine pretrial hearing quickly spirals into chaos. In Michigan versus Masonhurst, the court is simply trying to determine the status of a competency evaluation, but within seconds, things take an unexpected turn. From confusion about court scheduling to a shocking moment of courtroom misconduct, this case becomes less about legal procedure and more about behavior under pressure. The judge is watching closely, and one decision made in the heat of the moment is about to change everything. The question is, did Mason just sabotage his own case?
All right, we're here for a pretrial in this matter. He had been referred in the circuit court. What is the status of that, please?
Judge,
Oh, yeah. I'm sorry. Sorry, Ms.
go right ahead, Mr. Mansour.
Oh, no, I was just going to relay in the notes to the request. Mr. Lebo was going to request an adjournment for the competency report in that felony, and that date is the 7th of November.
Bro, what the? I'm supposed to get on probation tomorrow?
Mr. Munson, you're unmuted.
Oh shoot!
Yeah.
I'm sorry. I'm sorry. I apologize. It said I was muted at first. I apologize.
Judge.
So when
This is the moment that shifts the tone entirely. Despite being in a live court session, Mason is seen rolling what appears to be a cigarette, or possibly something else, and continues even after being directly addressed by the judge. Now, legally, this is critical. Courtrooms demand strict decorum, and any act perceived as disrespectful or defiant can result in contempt of court. And that's exactly what happens here. The judge doesn't hesitate. She interprets his actions as willful noncompliance. But here's the debate. Was this intentional disrespect or a careless mistake made under stress? Either way, the consequences are immediate.
Court, stop it.
Ma'am, I was already in the midst of it and I just turned my phone on and I saw that was my time up.
Okay, all right. Mr. Hurst is going to be held in contempt of court since he just decided he was not going to stop.
No, I'm rolling a cigarette.
I don't care what you're rolling, you're in court.
I'll put it down.
Now we hear Mason push back, claiming confusion and frustration with the system. He explains that he was given conflicting instructions, told to appear in person, only to be redirected to a Zoom call, forcing him to bite back just to connect. This adds an important layer. Logistical breakdowns can genuinely affect defendants, especially those without stable resources. But here's the tension. Does frustration justify earlier behavior? The court doesn't see it that way. Instead, the focus remains on accountability in the moment. Meanwhile, another key issue emerges, a delayed competency report that's been pending for months. So ask yourself, is the system failing him, or is he failing to meet the system's expectations?
Mr. Mansour, do we have a report back for him yet? Do you know?
I'm unsure, Your Honor. I can check right now.
Your Honor, I can jump in. Assistant Public Defender Davi Lebo from Mr. Hurst. We do not have a competency report.
Your client continued to roll a joint or tobacco or whatever he was rolling, despite the court's order to stop doing so until he was completely done and decided that he would stop at that point. When he was done, he would put it down. So he is in contempt of court. He'll be here in person next time. And hopefully we have a competency report by then.
Yes, Your Honor.
Thank you, Your Honor. Yes, Your Honor. When will this in-person date be?
I'm getting ready to give you that in a second, sir.
All right, thank you.
Ms. Woods, you were trying to say something as I was asking you to stop talking.
Yes, Judge. I just wanted to bring it to the court's attention that that he was referred to competency, I believe, in February, and that I didn't know if any defense counsel was following up with the with getting that report or finding out why it's been taking so long for that report to be completed. That's all, Judge.
When did you say the next court date is in circuit court, please?
November 7th, Your Honor.
I believe we're here on November 12th, right? November 12th, 2024 at 11 a.m. in person.
Okay, so 11 a.m. November 12th. Okay. Thank you so much, Your Honor.
This is 241114 SM, the People versus Austin Floyd.
Good morning, Your Honor. Jesse Fansel on behalf of Mr. Floyd. We've had today's time date set for sentencing. We've had an opportunity to review the pre-sentence report. Same appears to be factually accurate. No corrections, additions, or deletions need to be made. I put little boxes there, a couple of things that I'd like to address in terms of the recommendation.
Okay.
Judge, there is nothing in this report or anything that has anything to do with alcohol. They did an evaluation. It's low risk, low needs. And so I don't see any reason why alcohol restrictions would be, he knows he can't do illegal drugs and he has to use alcohol appropriately, but there's no reason why he should be restricted from doing so.
Hello?
In a sharp transition, the court moves to a completely different case, and the contrast is striking. Here, the defendant faces consequences for sending explicit images of his former spouse to a family, an act the judge clearly labels as retaliatory and unacceptable. Despite arguments about low risk and no substance abuse issues, the judge focuses on accountability and character. The result? 12-month probation, fines, and strict conditions, including no contact except for matters involving their children. This moment highlights a broader legal reality. The court isn't just punishing actions, it's addressing patterns of behavior and responsibility. So what do you think? Did both defendants receive fair treatment based on their actions? White right pointing backhand index. If you found this case as intense as it was revealing, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.
And in some states, this is a felony. It's revenge porn. It's a felony in a lot of states. $50 fine, court costs of $50, state costs of $50, and a victim's rights fee of $75, probation oversight fee of $450, and community service fee of $10 per day, for a total of $50. You're to do 12 months probation. You'll complete 5 days or 40 hours of community service as directed by probation and provide proof. He wasn't on drugs or alcohol at the time the incident occurred.
No, this is not related to that at all. And the report, he seems to have been honest with with Ms. Grasso, and she did evaluation of low risk, low needs. There's no indication that that's an issue.
Okay.
I was actually at a doctor's office.
That's classy. All right, you are to abstain from the use of controlled substances unless they're prescribed by a physician for the term of your probation. You will be subject to testing at your expense at probation officer's discretion if they believe there's an issue. You're to have no contact. You understand me?
Your Honor, she was originally in the waiting rooms, but she is, unless she came back. Apparently she left.
I didn't see her.
The parties have 3 children, and quite frankly, she initiates a lot between the parties, and I've explained to him no contact, but I would ask the court consider just relative to kids.
How do they do parenting time transfers now?
Is it, does she have physical?
She will drop them off at my house.
Okay.
So she drops them off and picks them up?
I will sometimes drop them off at her house. Before, we were doing it at a police station.
And then he coaches kids teams and she attends the games and stuff. So I would ask the court, limit it to the children.
Okay. So it's contact only for the purpose of parenting exchanges or other activities involving the children. She's not here for me to get any input from her, but it sounds like they're doing that anyway. Here to maintain employment and provide proof and obtain an order for fingerprints. It looks like you've already done that. Okay. All right. Hopefully you learned something.
Thank you, Ron.
You're all set.